it's a stop.
I noticed. Oh, well, I gathered.
Yes, 1968.
Good.
Fine vintage. You probably remember it well.
Potter eyes.
Yes. My lords, we left looking at, I think it was Lady Justice Andrews who asked me about the exceptional cases test, and I wonder if I perhaps went too far and have elevated it to some sort of aggrandized test that it doesn't deserve. So can I just take the court through the development where that comes from? And maybe we can skip over a lot of this very quickly because my friend very fairly took you to most of it in his submission. Start with sires and sires. So in the authorities bundle, tab 1. And Lord Cairns at the bottom of pages 12 and then over into the top of 13. That's where it starts. As was said at the bar, on dissolving a partnership of this kind, the ordinary course would be for the court to direct a sale of the assets, and necessarily a sale of the concern as a going concern to give liberty for proposals to be made by either party to purchase it before the judge in chambers. That's where one or other of the partners wants to bid for the partnership property. And Lord Cairns continues, my lords, those provisions are moulded in every case by the court to meet the circumstances of the particular case. And it appears to me that looking at the nature of this business, looking at the very small interest which was taken, it would certainly not be desirable in this case to have a sale or to bring these premises to the hammer for the purposes of ascertaining what sum ought to be given for them. So that's the starting point. We can then move on to Hugh Stevenson and Sons. It's in the second tab, and we go to page 31. And here, I think it's Viscount Haldane who says that in the last paragraph at the bottom of 31, in the absence of a special agreement to the contrary, and there is none such in the contract before us, the rule is that on a dissolution of partnership, all the property of the partnership shall be converted into money by a sale, and that the proceeds of the sale, after discharging all the partnership debts and liabilities, should be divided among the partners according to their shares. Now, there's actually no support for that proposition that that's the rule at all. And that isn't what the Partnership Act says. So I'm not sure that takes us any further. And again, we're still in 1918 at that stage. We can skip on to 1984, Latchen and Martin. And by 1984, over the years, we can skip to page 58. Where the court says, in a paragraph, the third paragraph on page 58 of the bundle, page 7 of the internal numbering, the normal course on the dissolution of partnership is to sell the assets. That's what the court will usually order in the absence of an agreement to the contrary. But as the Court of Appeal pointed out, citing Lindley on partnership, the rule is not inflexible and the sale is merely adopted in order that justice may be done to all parties. So that, unsurprisingly, is the guiding principle, doing justice to all the parties. Section 40 of the Act does not direct a sale, but only gives a partner a right to have the surplus assets applied in payment of what may be due to the partners. For that purpose, any partner may, on the termination of the partnership, apply to the court to wind up the business and affairs of the firm. The power of the court is not confined to ordering a sale, but is a broader power, namely to wind up the affairs of the partnership in such a manner as to do justice between the parties. That takes us on a few years later to Hammond and Brearley, and it's in Hammond and Brearley that we see this terminology of an exceptional case. But I wonder whether we've all, or certainly I, have misled myself into thinking that exceptional is some sort of test as opposed to merely being out of the general course. We see that in the order of in the judgment of the court at page 63, which my learned friend took you to in those two marked passages. What the judge there says is there's nothing in the Partnership Act 1890 which positively requires that the winding up of a partnership shall be effected by a sale. That's obviously true. It's true that a sale by auction is the normal way of realising the assets for the payment of debts and distribution to the partners. Well, that may have become the custom by 1992, but the decision of the House of Lords in Sires, to which the judge referred, shows that in exceptional cases, no definition, the court has a discretion to take a different course, such as allowing partners who wish to continue the business to acquire the share of another partner at a valuation. That is exactly what Mr. Bahia wants to do. He wants to continue with those properties and to continue letting them out, and indeed to continue the business to acquire the share of another partner at a valuation. The court continues, it's, I think, notorious in the Chancery Division that Sires is an authority far more frequently cited by counsel than applied, but the discretion which it gives seems to be a valuable one, which I think judges should not hesitate to use when it suits the justice of the case. And skipping on to 8, the judge should have considered whether the judge at trial might wish to exercise his discretion to wind up the partnership in some other way. In this case, it seems to be distinctly arguable that he might. The assets other than the goodwill have, as the judge pointed out, little value and detached from business as a going concern. It follows that the plaintiff is unlikely to do better, may well do worse, by sharing the prices realised by public auction than by receiving his share of a valuation in which the position of the defendants as special purchasers can be taken into account. On the other hand, an auction sale of the firm's computers, desks and so forth may well, and we've already had a look at that passage. So I don't want to mislead myself or the court into thinking that it has to be, there's some magic to exceptional case, that you need something truly remarkable as opposed to just a case in which you can do justice between the parties by something other than a sale. And it seems to be conceded that it's not just a sale at auction, it's a sale by, what I would suggest is whatever the receiver thinks fit. That was certainly not in dispute in relation to the other partnership properties. I can't see any reason why it should be for this one. Mullins and Lawton in 2002, at paragraph 119, went a little further, saying that in that case, provided one partner was bought out at a fair price, on page 104 of the bundle, paragraph 119 of the judgment, provided one partner is bought out at a fair price and the valuation exercise is carried out quickly, seems to me that he would have no ground for complaint if I made a buying out order. So the point is this, that the court can make any order it sees fit in order to achieve justice between the parties, and the aim of the court is to achieve a fair valuation of the assets. And that's why when the judge in this case said, look, doing it one way or doing it the other way is going to be fine, or is likely to be fine. Benj and Benj is, I think, the last word on this issue of principle. That's at, I'm not sure of the tab.
9.
Oh, thank you, my lord. I want to start at paragraph 48, which is page 184. Where the deputy judge in that case said, assuming there's been a dissolution of the partnership and assuming that the majority partner or partners want some course other than a sale as representing just between the parties, and that the court is satisfied that such an order would replicate financially what the other parties would receive on a dissolution, then the court can find what is a flexible and fair solution in the particular circumstance of the case. In other words, the court isn't bound to go down a particular path. The court will have regard, I'm reading paragraph 49, the court will have regard to a number of factors as stated in Sires and Sires itself by Lord Cairns, the nature of the business, the relative interest of the parties, and what it is that is sought to be done with the partnership business.
Isn't the key bit of paragraph 48 the words, and that the court is satisfied that such an order would replicate financially what the other parties would receive on a dissolution?
Yes, the judge below had to be sure that there was a mechanism in place that was fair. And that takes us back to Lord Justice Arnold's point. The centre of this dispute is the only way of valuing any partnership asset to sell by auction, which is the
What's
relief
the
that
fairest way to sell by auction?
well, with respect, I say that's not right. All selling by auction does is determine on one day the market price on that day. If there's a tube strike, you may not have the bidders. If it's raining, you may not have the bidders. It's not a reflection of necessarily of what a property is worth. It's a reflection of what people are willing to pay on that day for the property. And there are 100 different considerations that might apply to that.
You could say the same about a valuation. Valuation is any one person's view of what it's worth.
Well, it's an expert's view on what it's worth, yes. And indeed, in this case, of course, it isn't just one person's view of what it's worth, because we've got the evidence of Alexander Lawson, we've got the evidence of the single jointly instructed expert, and indeed, we've got what prices were achieved at auction for the other properties. And I'm going to show the court in due course that there's a cat's whisker between those three valuations.
How does that help us? Because the judge didn't have a crystal ball. So he couldn't have known what the prices were going to be for the other properties.
No, but he was right. And so if we take the, and this isn't meant pejoratively, but if we take the reductionist approach to this appeal, which is can you only establish a fair price by auction, then the answer is no, because the valuations show that they are also able to produce a fair price. And indeed, well, I won't ruin my own thunder, or I'll keep my powder dry and we'll look at the figures in due course. But when we look at the figures, we'll find that, as it happens, the buyers have, on the valuations, grossly overpaid for these properties to the benefit of the partnership, and therefore the Sidhu.
Can I ask you something else? Prompted by something that Mr. Rosen says in paragraph 48, where he refers to the majority partner or partners. Certainly Mullins and Lawton and Sires and Sires were cases where the departing partner who was being bought out was very much in the minority. And in Hammond and Brearley, I don't know what the proportions were, but he had no share in the goodwill, which was the peculiar feature in that case. Do we have any examples of two equal partners where there's been a buyout?
No, we don't. We don't have a case on all fours of this where one partner is dead, the partnership has come to an end, and 3.6 million was stolen from the partnership by the deceased partner.
Can I? Yes. Why does it matter that 3.6 million was stolen? I mean, Mr. Knox's point, which is the case you're facing, is, well, yes, we had a very stinging judgment against us, and we have to pay a very large amount of money, including interest. But that will all come out in the wash, and there's more than enough money to pay for it. You will get your money. So why does it matter that 3.6 million has been stolen? I understand the point that you initially made was it's very unfair if they can bid at auction because they've got our money, and we can't because they've stolen it from us. At that point, it seems to me, unless you're going to come back to it, is entirely disposed of by the proposal to enable you to bid on credit. Once you get over that point, why does it matter that they're bad guys and you're a good guy?
It doesn't, once you're over that point. Once you address that unfairness, then I accept that that doesn't matter anymore. The iniquity, this appeal is about vindictiveness. It's about making sure that Mr. Bahia does not keep those properties, the ones that he wants. That's the reality of it.
Why
We
not?
talked about
He could bid for them at auction.
Yes, and he doesn't have the same buying. Well, it depends how the court were. In the event that we get permission, that the other side have permission to appeal and are successful, there's going to be the most almighty unwinding necessary in order to achieve fairness again. Because, of course, in the interim, there's been further distributions to the Sidhus in order to equalise the payment. So all of those are going to have to be unwound as well. Otherwise, again, the Sidhus are left with more buying power. What they did, and this was a matter of fact in front of both the judge below and indeed in front of Mrs. Justice Joanna Smith, was they used the money that they had taken from the partnership in order to build up a substantial property empire. That was in evidence before both previous courts. So they used their assets to put themselves into a position where they had the opportunity to acquire these properties other than us. It's, I suppose, a different facet of the bidding war mischief that was looked at in one of the other cases we looked at this morning.
I haven't quite understood this point. It's my fault because I haven't got my head around the figures. But very broadly, under the judge's order, you took £5.5 million worth of property. We know that that leads to the next 1.9 million going to the Sidhus. But we're also told that overall there's something over £11 million worth of property. So that once you've taken account of the 5.5 and the 1.9, that's only 7.4. There should be about another 3.6 plus to be divided equally between you. So you should have 1.8 million in cash.
Yes.
And they should have 3.7 million in cash. Is that about right?
I
think
so,
yes. It's a bit complicated because you've used some of yours to buy one of the properties, but that seems to me to be irrelevant. Now, if the properties go back into auction and you are at liberty to bid, I don't see why you're still not at liberty to bid with the credit of what would come to you. So you only have to pay for half of it.
Yes.
And that you'd still have quite an opportunity, would you not, to bid for things you wanted without actually having to put cash in? I'm not sure.
You have to
talk me through that.
If we're going to start unwinding anything, I mean, one has enough experience as an advocate to see when the court requires a good deal of persuasion of one's point. If we're going to be unwinding anything, my first position is, I mean, obviously this is contrary to my case, is that properties 1 and 2 and that mechanism were completely fair, completely justified, completely vindicated. There can be no question that properties 1 and 2 should be unwound. I can absolutely see whether...
You say properties 1 and 2, and you said that earlier, but when we looked at what the order you actually asked for in your application notice, it was properties 2 and 4, I think.
No, it was 1 and... Well, I don't think so. I think it was 1 and 2.
1 is number 8.
No, 8 King Street was something wholly different.
But when you actually looked at the numbering, I noted that 8 King Street was the first of the properties on the schedule. Now, they may have been reordered. But that's why we're getting why we're getting mixed up. Right. That's the way that it works.
Right. Now I understand.
So there was a slight difference of, and I think that's where my lauders got slightly tangled up. But as I understand it, you're talking about properties 1 and 2 as the first 2 of the 4.
The Ealing property and the 44 to 48 King Street property.
Yes.
Let's not use the numbers. I'm sorry. That's
Ealing and 44 to 48.
Ealing and 44 to 48.
Yes.
Those come to 3.6.
Yes.
As it happened, there was, at the hearing, unbeknownst to us, there was a valuation of 8 King Street 1.3 million. That wasn't accepted by the Sidhus. The Sidhus came and said it's worth 800 to 900. So I said, maybe opportunistically, well, fine, we'll take the 900 valuation.
The judge wasn't very impressed with that.
No, he wasn't. But that, that was, it shows the sort of gameplay, if you like, about, on the one hand, they won't accept 1.375 as the valuation for 8 King Street. They turn up at the hearing with the valuation saying it's worth 900. In fact, they buy it for, I think it's 1.5 million at auction. It's quite a case, this, and there's an awful lot of background that this court has fortunately not had to deal with or grapple with.
But I think we've all got the picture that this is one of those unfortunate cases where each side totally distrusts the other, each side wants to score points off the other, etc. And each side says that the other side is the bad guy. So I think we probably got that impression.
Well, that's not fair. It's not fair because my client isn't trying to score points off anybody, just trying to bring this partnership to an end. And if one wants to characterise somebody as a bad guy, which I don't, and I'm not urging the court to do that, read the judgment of Mrs. Justice Joanna Smith.
Yeah, well, that's undoubtedly, unequivocally in your client's favour.
Yeah.
As are the 2 applications certified as being totally without merit, being by Mr. Sidhu subsequently. And indeed the contempt of court application. I've slightly lost my track, I'm sorry.
I'm sorry, it's my fault.
Sorry, I think it was prompted by my lord's question about one of the companies
Oh,
was
yes.
number 1 and number 2. And I think you were submitting to us that come what may, and whatever view we take, Ealing and 44 to 48 are worth more or less the 3.6, and therefore no justification for unwinding anything to do with that. And then I think you were going
That's
to
right.
come on to say something else.
Thank you,
about
my
that.
lady, yes.
Okay.
And then the other two properties, which I'm now not going to number, can be, I can absolutely see why there's a perceived unfairness about that, because it gave us more than it was worth. If we unwind those, more than we were owed, if those are unwound, then also the sale of 8 King Street has to be unwound, and the interim distributions of cash have to be unwound, because otherwise we're left in a position where we didn't have the means to bid for other partnership properties at auction. We couldn't, for instance, bid at 8 King Street because all of our money was already tied up in the 4 properties that had been transferred to us. So if you're going to start unwinding something, then unwind it back to the status quo ante, and we start from scratch from there. And that brings me on to an issue about proportionality and reasonableness, and why I actually say you shouldn't give permission to appeal in this case in any event. Because I made the point when I was on my feet at the invitation of a learned friend earlier, that at the moment the parties are completely whole and aligned. And so when one starts to look at unwinding everything, and we start getting into who's paid what for what, how much rent has been received, and starting to go down that line, and then getting into squabbles about who paid what and whether that was reasonable. I notice in my learned friend's skeleton argument, he says it's now accepted that if this is unwound, his client will have to pay up to half of the expenses that have been incurred in those unwound properties. Can't for the life of me understand why it'd be up to. It is plainly going to be half. But that just prefaces the dispute that we're likely to hit down the road and the further satellite litigation.
Well, I take your point that if the judge's order is set aside, there are potentially unfortunate consequences for the parties. And that's, in a sense, that's true for both of them, for the reasons that you've just been explaining. But that's often the case where judges make orders that are upset on appeal, isn't it? And as a matter of principle, if the judge's order was wrongly made on the day it was made, do you have any basis for submitting that this court should not set it aside?
Yes, I do, and it's one of pragmatism and practicality, and it's supported by Lord O'Hagan. If you look at page 20 in the authorities bundle, this is in Sires and Sires, so as far back as 1876. Lord O'Hagan's speech is at the bottom of page 20. In the top third of his paragraph, as it were, there's a sentence which begins, "But I agree with my noble and learned friend." He says, "But I agree with my noble and learned friend who last addressed your lordships, that it behoves us, if possible, to deal with the matter effectively and prevent the necessity of farther litigation." Now, I am not suggesting for a moment that this is binding authority for the proposition that your lordships and your ladyship should be pragmatic and avoid further litigation. But there is a question of proportionality here. What is the point of this appeal? The only answer is to make sure that we get the right value for these properties. And the judge, however mangled the order was, or the drawing up of the order was, he came up with a mechanism which absolutely, completely secures a proper valuation for these properties. Because he said it's the valuation that went unchallenged for up until the day before the hearing as a bare minimum, and beyond that, it's a higher value if that's what the single joint expert valuer produces. And so the only
For some of the properties.
sorry,
For some of the properties, not others.
for the Schedule A properties.
Well, I thought you said it was higher for some and lower for others.
Well, as it turns out, we are told.
Yes, but that's entirely to the benefit of the partnership because
Yeah, because of the way
because
it
we don't
works.
get it. It's a one-way bet,
Yeah.
my lady. It's not the case that we get.
I understand that. You have to give credit for the higher of the amounts, regardless of whether it's the original valuation or the later valuation, and it's done on a property-to-property basis.
Correct, and not only that, but it showed the single joint expert suggests that we overpaid for two of the properties by more than £250,000, which the partnership has the benefit of. I'm going to
It's a draft report, I should say.
yes. So what I want to do is get into the numbers, and we can, because I think they're important when one looks at the situation we're now in. The new note from a learned friend, I don't know where that ended up, but at the end of the supplemental bundle, there is a letter from Hill Dickinson, which shows what the properties were sold for. It's at page 213, right at the very end. It should be tab 23 of the supplemental bundle. And I'm looking at page 213.
I'm afraid I don't have that.
It came in late. I
Yes.
added.
Yeah, likewise.
It didn't reach me.
So if you could just read out the figures, please.
Just read the figures out, it's fine.
I will, but may I? I do have a spare copy of that.
That's really kind of you.
May I also take the opportunity of handing up the draft page of the report as well? The page of the draft report, I should say.
Thank you.
These figures are not, these are common ground, they're not in dispute.
No.
The Alexander Lawson valuation column, of course, were valuations done in 2022, and the sales were achieved, I think, almost entirely in 2024. In fact, they were entirely in 2024. So, in respect to the first property, that was the High Road was at the agreed value, same with 2A Broadway. 136 High Road did not sell, but there is an offer of 1.15 pending, so that would be higher than the price. Of course, that's by private treaty, not by auction. Stroud Green was transferred pursuant to the order. 47 The Marketplace sold for less than the Alexander Lawson valuation at auction. 97, nearly 98% of the auction price. 49 The Marketplace sold for slightly more, 103% of the valuation. 8 King Street was a special purchase. That was by a Sidhu corporate entity. They paid 1.5 for that over the valuation, but there was a marriage value because they own the property next door at 6 King Street, and so it was obviously particularly valuable to them. 13 Damson Wood Road was valued at 260, but only sold for 190,000, 73 odd %. And that was sold by private treaty after the auction failed to complete.
That's the worst, really, performer, isn't it? That one.
Yes, for all, and it's the others were within a couple of % of the valuation. And that's one of the points I want to make, that although one can say auction is absolutely the best way of finding the price, the valuations are pretty good because they are within a couple of percent of what's achieved at auction. A couple of percent below, a couple of percent above. With that one outlier grossly below. 3/4 of the valuation. And what I say you can see from just those figures is that it's self-evident that auctions don't necessarily achieve the best outcome. And that's what the judge said in his judgment, because he said otherwise all properties would be sold at auction, assuming that everybody wants to achieve the best price they can. So as a whole, the sold properties have sold for an average of 95.6% of the Alexander Lawson valuations. That's, I don't want to mangle stats and maths too much because that's just looking at the price sold against the value. And we can see from the figures that they're a little more nuanced than that. And so one asks oneself again on the core of this appeal, whether this is what the judge said, a dog in the manger approach. We're not really interested in getting a particular value for the properties. We don't want the properties ourselves. The Sidhus were asked that explicitly in the court below and said no. We just don't want you to have them. Now, we've got the Lawson valuations in August 2022, which weren't disputed until shortly before the hearing. We've now got the draft joint valuations from the single joint expert. And it's worth looking at those and comparing them with the Alexander Lawson valuations. So for 44 to 48 King Street, Alexander Lawson said that property was worth 2 million. Harris says 2.175. So we would need to pay an extra 175,000 into the partnership. 99 to 101 High Road, the Alexander Lawson valuation 2 years ago was 1.6 million, 1,625. And there's a £60,000 difference with the Harris valuation, 1,685. But for 47 Stroud Green, the Alexander Lawson valuation was 750,000, but Harris, the jointly instructed expert, only values it at 625,000. So minus 125. And for 2 to 2A the Broadway, that was valued by Alexander Lawson at 1.2 million, and Harris values it at 920,000. So minus 280,000 for the partnership. So on those figures, and if we have to pay in the extra for the new valuations, the partnership is nearly £500,000 better off under the judge's mechanism than under what Harris suggests the properties are actually
You
worth.
eventually get half back, of course.
Yes, that's right. In exactly the same way as the...
I mean, the one figure that leaps out as being a little out of kilter is the huge difference on the Stroud Green Road property between the two valuations. It makes me wonder whether anything has happened in the intervening 2 years to suddenly make that one take such a huge plummet in value.
Well, I think, funnily enough, there is some discussion about market conditions, and there's some discussion about the fact that the previous valuations were done in the grip of coming out of the pandemic.
Yes.
So there are differences, and one also has to remember that you can't. Looking at the Harris valuation, one is actually looking at a 5%, a 10% range, 5% either side of it. And the point I want to make is this: that if one unwound these transactions and put them into auction, the partnership would have to do 7.5% plus costs better than the valuation in order just to wash its face on what the buyers have already paid and will have to pay as a result of these valuations.
How do you get to that 7.5% figure? I'm sorry.
I get to it by looking at the valuation, the Harris valuation, which values those 4 properties at 5.4 million.
Yes.
Looking at the Alexander Lawson valuation of 5.575 million.
Yes.
Looking at the 175,000 and the 60,000 that we have to pay.
Is that common ground that you have to pay that? Because it wasn't obvious to me on a reading of the order that's what the judge said.
That's absolutely what the judge said.
Right. But
I
it's
can't
done on a property by property basis.
Yes, I can't shy away from that. I mean, it would completely suit me to say,
Yes.
well, we'll go with the
Yep.
you get the partnership gets 5.4.
Yep.
But that isn't what he ordered, and that's why I say you can be really sure that the mechanism he ordered was actually quite clever. It said, look, we've got an absolute minimum here, and you can only go up. And then from the 5.4 to the 575 plus the 175 plus the 60, you also have to take into account the difference in valuation, the 280 for Broadway and the 125 for Stroud Green, and that's where I get to it. Add on to that then the costs of selling by auction, and you're an order of magnitude. Well, you're not using that as a term of art. You're a significant way away from what the properties have in fact achieved at auction compared with the valuation, just to get back to the same position. And that's why this is cutting off your nose to spite your face in this appeal.
So you said you'd need a 7.5% uplift.
Yes.
On what? On the 5.4 million or on the 5.575?
On the 575. So the single joint experts come up with a valuation for the four properties, 170,000 less than the buyers have already paid, and because of the mechanism that the judge adopted, they'll have to pay a further 235,000 as well. So what will happen, my lord, is that the buyers will have to pay a total of 5,810,000 for the four properties. That's 7.5% more than the single joint expert thinks the properties are worth. And if the auction achieves, as the previous auction achieved, the values that the expert valuer thought they should achieve, that's where I get the 7.5% from.
Thank you. I understand that. Thank you very much.
So I say it's highly unlikely that an auction would achieve such a result for the partnership, and this is dog in the manger, to coin the judge's phrase, writ large.
Where does the judge say that?
He says it. Maybe I don't know. Maybe he didn't say it in his judgment, but he certainly said it in the hearing.
I don't remember.
Leonard
seeing it in
Junior
the
will have a
judgment.
quick check for dog or manger in the judgment. We'll see if we can find it.
Thank you.
I was present at that hearing. The way it arose was that the judge asked the cities whether they wanted any of the properties, and the answer came back no. In the judgment, the judge expresses his scepticism that they could have acquired them because they said, we're impecunious, the estate has no money, they've got the judgment debt, and they said they didn't want them. And so it was that which caused the judge to say, all of this complaint then seems to be more dog in the manger than anything else. So the hope of achieving more than the 5.8 million, which will be the figure that the buyers will pay for those properties, has to be balanced against the steps and costs of unwinding the original order, and those are not inconsiderable. Leonard Frame waves away all of the complexity in that by saying, well, you just sell them.
Well, I repeat the question I asked you earlier, and I'm still not sure what your answer is. If the judge's order is reversed, there is absolutely no doubt that it will have adverse consequences, as I see it, for both parties, because of what's been done in the meantime. But why is that a basis for resisting the appeal? If the judge's order was wrongly made?
It's a basis for refusing permission to appeal in the first place, and looking at whether there's going to be any benefit to any party in permitting this appeal.
So what's the legal principle?
Purport.
We assume, for the purposes of this argument, and of course you argue to the contrary, so this is a hypothesis. We assume that the judge's order was wrongly made. Now, why does the fact that it's been carried into effect and therefore unwinding it will be costly any legal basis for upholding the order?
proportionality, the overriding objective, allocating courts' resources appropriately, fairness between the parties, the futility of the appeal.
So in other words, we might as well get rid of the Court of Appeal.
Yeah.
Well, I'm not going to suggest that today.
You want to
Certainly
wait
not in
for
front
the
of this
judgment
court.
first.
Anyway. No, I don't. I mean, of course not, because a lot of appeals do actually have a purpose. They have a purpose in dealing with an unfairness. There isn't any unfairness here. The only potential unfairness came from...
But what you're focusing upon is events subsequent to the order. And I appreciate the very valid concerns that your client has on that score. I'm not trying to say that his concerns are misplaced. On the contrary, I see the force of what you're saying. What I'm struggling to understand is what the legal relevance of those concerns. As a matter in the real world, that's very important. I appreciate that for any litigant, obviously. But nevertheless, I mean, in a sense, what your submission goes to is this, that both parties are going to be adversely affected because there was no application for a stay of execution when there should have been. And I see the force of that argument, but I repeat, if the judge's order was wrongly made, why is that a basis for refusing permission to appeal? And why is it a basis for refusing to set it aside?
Well, I can see the force of your lordship's point as well. Aren't we in a golden straight type scenario where one asks oneself rhetorically, why should I hide my head under a... We're getting very biblical in this appeal, but why should I hide my head under a bushel and keep my eyes away from the light in the light of what I have now found out? Rather than doing justice between the parties now. I mean, obviously, both the court below and the Court of Appeal tries to do justice between the parties. And I'm still addressing effectively whether there should be permission to appeal rather than engaging so much with the grounds, which hopefully can take much more shortly. But the...
Well, you're on slightly stronger ground in terms of permission to appeal because the question of permission is discretionary. Whereas what we do, if we allowed an appeal, is not quite so straightforward.
Exactly.
But I think what you're really looking at is the second limb. Obviously, the question is there an argument with a real prospect of success? If my Lord, or Justice Arnold postulates, let's say there's a cogent argument that the judge got it wrong, right? Get over that particular hurdle, there's still the question of why should we grant permission? And I think the answer to that is, well, you then start bringing in the overriding objective and say, well, where is it actually going to get you? And it's going to cause a great deal of grief and possibly end up with everybody worse off. And therefore, interesting though it may be, why should we entertain the appeal?
That's exactly how... I mean, maybe I should have phrased it better, but that's exactly what I'm addressing.
No, I think it's what you're getting at.
Well, it's what I was trying to get at.
Yeah.
It's the futility of this and the absurdity of... I've described it as cutting off your nose to spite your face or vindictiveness or whatever. It's the absurdity of trying to unwind... I accept that when the judge went further than the order that we were initially seeking in front of him, he probably went further than he should have. But he recognised that and said the way to address that is by the rebalancing of the way that we're going to divide up the assets immediately afterwards. That happened. Of course, he didn't know that was going to happen. He ordered that it should happen. That's happened, and the parties are now at stasis. And if learned friend could point to something and say, look, we've got buckets of evidence that shows only auctions provide the best price for these properties, then I would be in more difficulty. But there's no evidence of that at all. And indeed, all of the evidence that we do have shows that the auction prices are within, I call it a cat's whisker, whatever, however you want to describe it less colloquially, within a tiny margin of the valuations. And because the judge put in the mechanism he did about us having to, using the Alexander Lawson as a base and only going up from there, in effect, my client would have paid more than £500,000 over the valuations than he would otherwise have had to. That gives this court so much comfort in what might possibly be achieved at auction, particularly when one thinks about what reserves you'd have to put in and so on and so forth. That that's a good reason for not upsetting the cart horse, for not upsetting the apple cart, or causing the horses to run at this stage. So that was all on permission to appeal. On the merits,
Can I, just before you leave that, your submission is, even if the court is satisfied within the meaning of CPR 52, whatever it is, that there is a real prospect of success on the point of law, the court retains the discretion to refuse permission on the grounds of proportionality and practicality. That's what it comes to.
yes, it does, and I do say that.
I just wondered, do you have no authority? I'm not criticising you for not having it, but just as a matter of interest, do you know of any authority
No,
on the point? Because certainly I think the usual practice is, if there's a real prospect, then it is appropriate to grant permission.
yes, but that I agree. I mean, so that's also my experience as well.
Yeah, well, the line of authorities, I think, that prove the exception are the ones where the appeal is purely academic.
Well,
So there may be a real prospect of success, but it's an absolutely academic appeal because it gets you nowhere. And there's a whole line of cases on whether the Court of Appeal will entertain a purely academic appeal. And in some cases it will, and in some cases it won't. I had occasion to look at those cases.
well, Leonard Junior deserves a pat on the shoulder because that was precisely what he just whispered to me as your ladyship was speaking.
But can you say that this appeal is academic?
Well,
You say it's worse. It's not that it won't achieve anything. It will achieve. It's very likely to achieve a worse position for everybody.
yes, I do say that.
I don't think you can say that it's academic now. No.
But I wouldn't define it like that. And I don't think you have to. If one, neither saying that the Court of Appeal should be disbanded, nor am I saying that your lordships and your ladyship need to read CPR 52. But were you to, you'd see that there is that element of discretion. There is that element of futility involved in deciding whether to give permission to appeal. And otherwise, I mean, one asks rhetorically, why did well, I suppose there was a different point there as well. I was going to say, why did Lord Justice Lewison retain this point about permission to the full court? But I think, in fairness to him...
At that stage, you were taking the point.
We were.
You couldn't unwind it.
Yes, we were. Yes. Which we know.
Which is a different point.
So, yeah. And which I obviously don't pursue.
Thank you. Yes.
I can take the merits, I think, fairly quickly because we've covered a lot of the ground anyway. But the grounds of appeal don't disclose an error of law. Go back to that evaluative judgment. It's a question of how the judge exercised his discretion.
Well, it's a question of whether he properly applied the principles to be extracted from the cases.
Of course.
To the facts of this case, isn't it?
Of course.
Once you get into discretion, then we're all well aware that we can't interfere if we wouldn't have made the same order, as long as it's within the reasonable bounds of what he could have ordered.
Of course.
And you say this is a paradigm case where the judge applied the principles to the specific and unusual circumstances that were in front of him.
Yes. And I won't say any more about that than this. Just wanted to correct. I criticised my own friend for the way he put the test. In paragraph 58 of his skeleton, he says, "The normal and well-established rule is that upon a dissolution of a partnership, each partner or personal representative of a deceased partner is entitled to insist that all partnership property is sold. That's not right. Insist doesn't accurately reflect the authorities. It's reversed. What in fact in Hugh and Stevenson is said is no one partner has a right to insist that any particular part or item of the partnership property shall remain unsold and that he shall retain his own share of it in specie." It's a subtle but important shift from the lack of a right of a partner to insist that he obtains property in specie to the right of the other to insist on sale. And we say, in fact, there's a general discretion conferred upon the court to do either, and neither party can insist that the court does one thing or the other. Indeed, and to be fair to my learned friend, at paragraph 61 of his skeleton, he says the Sidhus accept there is no absolute rule that partnership assets be sold upon dissolution, which I think contradicts what's said in 58. The proposition that personal representatives are of a lesser standing than partners just comes from Lindley and Banks. It's in Principle 9, page 28, tab 15 of the Authorities Bundle, at page 286. I'm not pushing this point any more strongly than is written in the Lindley and Banks article, extract. Page 286, Principle 9. The right to wind up the partnership affairs is, however, personal to the partners, so that the representatives of a deceased, insolvent, or mentally incapacitated partner will not normally be permitted to interfere. We're not going to say any more than that. Actually, I lie. There's no well-established rule on the authorities cited that the personal representatives can insist, to use my old friend's language, on anything. I've dealt with the normal rule exceptional circumstances point immediately after the short adjournment. Moving to ground 2 then, if I may. Swift repayment was a valid issue for the judge to take into account. And it may be that I don't need to, if the court's with me on the fact that the Ealing property and the King Street property are unassailable, then it may be I don't need to go too much into this. But
I wouldn't make any assumptions about anything, Mr. Tennant.
in that case, the first point is that the swift repayment point was plainly right, or at least not obviously wrong. The court ordered the Sidhus to pay back the money that they had extracted from the partnership at the end of the judgment in April 2022. It was only upon the transfer of these properties in 2024.
Sorry, can you explain to me in what world your client is not fully protected by delay by 8% interest?
Well, it's not there are two answers to that. The first is that 8% interest simple is in fact a perfectly standard rate nowadays. It's 2.5% over base. The second point is that this isn't a question about the money, it's a question about the properties. So I have to accept that if the court is not prepared to allow the property to be transferred in specie, then plainly there is security for the against the other properties to allow him.
I'm sorry, I may be missing the point here, but I thought you were addressing the point that the judge was right, you say, or at least certainly not in error, to have regard to the desirability of the judgment debt being paid quickly. Now, why is that not a question of money?
Well, it's a question of. Well, I mean, maybe I've been addressing orders of the court wrongly. But
isn't the time value of money normally measured in interest?
There are two issues, aren't there? Yes, the time value of money is normally measured in interest. It wasn't just about the money, it was about the properties. It was also the perfectly reasonable expectation that a court's order should be complied with.
I'm sorry, I'm really struggling to understand this because you've twice now replied to my question by saying, in effect, this is not about the judgment debt, it's about getting the properties in specie. But the point you're addressing is all about the judgment debt. And there seems to be a disconnect.
It's not about the value of the judgment debt, it's about the time for payment of the order compelling the Sidhus to restore money to the partnership. If the Sidhus, so we had the judgment in April 22. If the Sidhus in May 22 had paid that money back into the partnership, then this whole point about whether they had paid the judgment or not would never arise.
Well, of course,
we'd have asked for an
paid it.
Yeah, exactly. So we'd ask for an
Let's postulate this. Suppose a third party owes the partnership money, you get in the money in the usual way. I mean, the point that's been made against you is that by Mr. Knox is that the normal way is you realise the assets and then you do the accounting between the partners, and that would include any debts that either of them owe to the partnership. So you're putting the cart before the horse.
With respect, no, because in the meantime, the properties have to be, the only way to realise the value of the partnership is to sell the properties. And the properties are going to be sold with the Sidhus having all of the assets that they'd taken from the partnership available.
Well, as my lord has already said, that you're insulated from that particular problem by the credit point. They're able to bid on credit, and therefore they don't have to worry about the other side using all the money that they've filched from the partnership.
I do accept that. In parentheses, I remind the court that was a proposition put forward for the first time in the hearing.
Yes.
But yes.
Can I ask a slightly different point, which is that this is a hearing in the autumn of 2023 in which the proposal for auction was either December or February. So, no,
it wasn't, my lord. What happened was that in that hearing, Mr. Sidhu turned up with an email from a contact of his at Allsops, which simply said that our next auction is in December, and there was a cut-off date for putting those in days after literally days after the hearing. Our next auction after that is in February, and so there wasn't any evidence of it. There was a piece of paper put before the judge, but there was no. And of course, it also emasculated the powers of the receiver for him to determine the best way of selling the properties.
But let's assume then that's not certain, but there's at least a prospect of it being sold within 3 months or 6 months. Does that really make a substantial difference? I understand entirely that court orders should be complied with. I understand entirely that you're entitled to be put in the position as if the court orders had been complied with. As my lord says, if you've got a sale within the next 3, 6 months, or even a year, and in the meantime you've got interest running, you will get your money. You're secure for it. Why is it a significant consideration that giving you the property today is a means of discharging the judgment debt as opposed to waiting 6 months for it?
It's not a massive point. I accept that. But I think the premise of your lordship's question is that putting a property into auction equates selling it. And that's, we found, not to be necessarily true.
Properties don't always sell. But on the other hand, there are regular London auctions of investment properties.
Of course.
It's not as if it's a rare beast.
Yes.
Can I ask you something else, which is, suppose, I mean, most of this judgment debt was owed to the partnership, I understand that, so the only way of enforcing it is through a mechanism in the winding up. But suppose it had been owed to you directly, so that you had all the normal rights of a judgment creditor. The estate's asset against which you would first look to enforce, and you might have rights against the executors as well, but you've got a judgment against the estate. The estate's assets is its interest in the partnership. Its interest in the partnership is an interest in, it's a beneficial interest in property. And the way you enforce against beneficial interests in property is by getting a charging order. But a charging order doesn't entitle you, as the judgment creditor, to say, you owe me 3.6 million, you've got interest in this property, so I'm going to take it. There's no mechanism in the court to do that. What it enables you to do is to get a security on it and then have it sold. And why is that not the same? Why is that not the same in a case like this?
Well, I think there are two different points. The application, as I've shown, the application was before we knew there was a judgment debt. The application came in the original trial. We were always going to ask for the property to be transferred to us.
I understand that. But this point we're on is that the judge was plainly right, or at least not obviously wrong, to have regard to the desirability of a judgment debt being discharged sooner rather than later, and that's a reason for giving you the property as a means of satisfying the judgment debt. And so my question is, that seems to put you in a privileged position to most judgment creditors who can't take their judgment debtor's property and keep it. They can take security of their judgment debtor's property and have it sold.
Yes, I think it's eliding two concepts. I think, in fact, it killed two birds with one stone. It allowed us, it made good our application to have the property transferred in specie, and as it happened, it also dealt with this issue of non-compliance with the order, with the judgment order.
Yes, I mean, you've been very clear that as a matter of history, you made the application before the judgment debt arose, and you would have made it anyway because your client's desire was to obtain these properties in specie. And yes, you relied upon the judgment debt, but you would have made the application anyway.
Yes, I think that's fair.
Yeah.
Thank you.
Maybe my learned junior is much more au fait with property transactions than I am, but so he's reminding me of a section in our skeleton, which is at page 181 of the core bundle, paragraph 24. I can't now speak to this any more than we wrote in our skeleton 6 months ago. But what we said was enforcement against the estate, page 181 of the core bundle. Enforcement against the estate's representatives would be hugely wasteful of the court's and the parties' resources. As regards the partnership share, a judgment against a single partner, here the estate of the deceased, as opposed to a judgment against the partnership, cannot be enforced against the assets of the partnership. However, the share of an individual partner may be the subject of a charging order and ancillary receivership on the application of the judgment creditor pursuant to section 23.2 of the Partnership Act. This procedure is obviously unsuitable in the present case. It still fails to realise the assets or to restore to the partnership that which the deceased and his wife took from it. I don't know if that's an answer to Lord Justice Nugee's question, but I do know I can't offer a better explanation.
Thank you.
I'll just take these very shortly. The judge's point that there was no certainty in sale by auction of the price, he was entitled to take that into account. His point that it was going to cost less than going to auction, I think was probably him taking judicial notice of he's got a practice in property and property transactions. He wasn't obviously wrong that valuation would cost less. What we now know is that it will have cost less. What he did know was that the auction cost would be, at least on those valuations, would be nearly £75,000. There's nothing in the issue about whether there was going to be an interest-saving benefit to the parties. I mean, it was obviously right. What we said in our skeleton was it was plainly correct for the judge to hold that the estate of Mr. Sidhu would benefit from interest ceasing to run. The point that he made was that the appellants had been complaining about the interest running on the judgment debt, and that was it was continuing to run, and we gave references for that in our skeleton. The reference, I'm not going to turn it up, it's paragraph 31 of our skeleton supplemental bundle, tab 9, page 153. I'm not going to spend any time with this court on the respondent's notice. We've said all I want to say about that. And so to sum up, we say the first point is that permission should be refused for the reasons we've canvassed in oral argument. And if permission is granted, nonetheless the appeal should be dismissed or upheld for the reasons in the respondent's notice. If the court is minded to unwind the judge's order in any way, I think that's going to be very complicated, and it may be that the court would invite us to make written submissions on how that could happen in the event that that's the judgment that the court comes to. It's illegal. Okay. Just to be clear about the properties, what I've described as the Ealing property is 2A, the Broadway, and the other property is 44 to 48 King Street, comprising the lettered properties as well.
Those were the two which you originally sought.
Those came to, yes. I was going to say they were number 1 and 2, and then I was going to fall straight back into that debacle.
They're not 1 and 2 as they're listed in the
No, you're-
judge's judgment.
Your lordship is right, and I am not.
4 and
1 and 4.
1 and 4.
Yes.
Apparently they're not the right ones.
No, it's all right.
Yes, Mr.
No, it's not right. Apparently we've got it wrong.
Oh, I'm sorry. 44 to 48 King Street and 99 to 101 High Road, East Finchley. Is that right? Right.
They are 1 and 2.
Right.
But that's not what your skeleton said, what your order attached to your application says, unless I have misunderstood it. Maybe this point is not significant, but it's...
Our skeleton is at tab 12 of the.
Where do we...
But maybe it's the order that we were seeking.
It's
that's
the
more.
draft order attached to
So that's
your...
tab 3. Sorry, it's it
tab-
is 11.
Well, if we're looking at page 174, if that's the right page, the properties are listed in the same order.
Yes, but no,
Right.
page 172 is what I'm looking at.
So 174 is the 172 is the order. 174 is the schedule.
This is the draft order attached to your application notice, and you showed us this. And paragraph 4 at the bottom of 171 sets out completion, and it's forthwith for the Broadway, West Ealing, and 44 to 48 King Street, which is not what you've just told us.
And it's not what's in the skeleton, because paragraph 29,
Ah,
182, paragraph 29, relates to the 4.
Looking at page 174.
Oh, yes, it does. 183, sorry, it's paragraph 32. Sorry to cut across you, Mr. Deming. The draft order attached to the application envisages the initial transfer of 2 properties by way of an interim distribution, 2 to 2A the Broadway, which is property 4, and 44 to 48 King Street, total value 3.2 million.
Right.
Yeah. And then the others would be dealt with at a later stage. So it wasn't actually number 1 and number 2, which would have been 3.625 million. For whatever reason you decided to go for the other 2.
Well,
For one of the other 2.
my instructions are clear now, and it is on page 174.
yeah.
Properties 1 and 2 in Schedule A coming to 3.625.
Yes, and the logic of that is clear, not least because that's Mr. Knox's submission on his ground 3.
Yeah.
But as a matter of history, I think what we've just found out is that the draft order was seeking an initial transfer, as it was described, of properties numbers 1 and 4.
Yes, I think that's right. I'm sorry, it's my
Not
fault
at all.
being
No,
so
it's
confusing.
it's easy to get confused in these matters. Thank you. So, Mr. Knox.
My lord's first point, I don't defend says this is an appeal against an evaluative judgment in reverse to spirit room. We say that's not right as a matter of analysis. We are saying there was an error of law by the judge in understanding what comes within the sort of things that amount to exceptional circumstances and what sort of thing justifies a departure from the normal rule, for the reasons I've given. That's one error, we say an error of law. And we also say an error of law, manifest error in any event, is inconsistency in his judgment because he posits his judgment in making an order, a forced order of transfer by reference to the debt of 3.6 million, but he orders a transfer of 5.575 million worth of properties. That's a plain error. So this is not a mere matter of taking a different view on evaluation. There may be 1 or 2 points here and there, but overall there are proper errors which we can point to. Second, the exceptional circumstances test. The point about the normal rule, if I can call it that way, is as my Lady Justice Andrews has put it, going to market is the fairest way of dividing, the fairest machinery for dividing up the assets between partners. For the reason I gave earlier, but if I can just repeat it, partner A can buy if he wants and pay the price he attaches to the property in question, even as a special purchaser. He might really want this property. So be it. But if he really wants the property and he's prepared to pay whatever the price is, then the partnership, and therefore partner B, is entitled to put into that rather than put into a valuation. Because the great advantage for someone who really wants something is we don't know what price he is really prepared to pay. I'm not saying this would necessarily apply in this case, but as a matter of general principle, if I really want something, I might actually be prepared to pay quite a bit more in real life than others would. And I don't want that found out. I don't want to be exposed to that risk. And I say the reason it is fairer is because, first of all, partner A can be forced to buy at the price he really attaches to this property. And either he does pay more, and that's good for the partnership as a whole, or he pays less, even less than the valuation or whatever. That's good for him. He can't complain. There is no real complaint partner A can have if he is forced to go to market if he wants a property. The next point is the problems of unwinding. First, I say that is not a legal basis for refusing to set aside an order that was wrongly made at the time. We fought on that ground below, and to say, oh well, too much water under the bridge, we're not going to set it aside now because it's academic, or because it will do too much damage, I submit is not a principled reason for refusing permission to appeal or dismissing an appeal. It might be a reason for building in protections in any order that is made as a consequence of allowing the appeal, but it is not in itself a basis for refusing permission or refusing a good and otherwise good appeal. And in particular, we say there is unfairness in the judge's order, precisely for the reason, or potential unfairness, precisely for the reason I just mentioned a moment ago. Mr. Bahia obviously wants these 4 properties. Our position is they're jolly good properties. They're, you can see, fairly valuable properties. They've got good tenants in and so on and so forth. He says he has an emotional attachment to them. Well, we say, okay, if that is so, why can't he just buy them in the market? And this is, and my lords, my lady, you'll remember in, I think it was Lord Justice Hoffman's case, he said, building in a protection for the special purchaser. I can't remember exactly where it appears, but it's in paragraph 7 or 8, he talks about the valuation can build in the protection for someone as a special purchaser. And we say that here, the problem here for the respondent, we say, is Mr. Bahia obviously really wants these properties, and he doesn't want to go to auction to get them. And we say that is an unfairness to us. And so, and another consequence is this: you cannot use the bids on the other properties as an indication what would happen here, where there is no special purchaser and Mr. Bahia is not particularly interested. It's not a good guideline. It may land up much the same, but one cannot at this stage possibly say that. And we're entitled to have him go and bid if he really wants to. The next point we make on the, what you might call academic stroke, causing difficulty in the argument. There is, in my submission, no difficulty at all if the 4 Schedule A properties go into auction now, let's say next month or whatever, as opposed to valuation. What would happen is Mr. Bahia would, on one alternative, buy them all, buy some of them, or buy none of them. But then what would happen is the proceeds of those properties would simply go into the partnership. What is the difficulty, one asks rhetorically, with that? My learned friend says, oh, well, what about all the Schedule B properties? To which we say, so what? There's no need to hitch, so to speak, what happens to the Schedule B properties to the order we are seeking. There's no cross appeal, as I understand it, on the footing that if you were to accede to our application to send the 4 Schedule A properties to auction, then the rest of the order should in some way be altered.
Would there be a problem about him selling them to himself?
Well, that might require them to be revested in partnership, I can see that.
Yeah, I mean, I was just thinking that, because
yes,
originally my lord had said, well, does it matter as long as they're sold? And the answer is, well, it really very much depends on who buys them, doesn't it?
Yes, yes, I think that is right, my lady. At the moment, I haven't got an answer to that, but I think it's probable that the that reason, bearing in mind he is an interested, on the face of it, an interested purchaser, it would have to be the partner, the partnership, as we're being the notional, at least, seller, the person entitled to sell.
Well, I mean, maybe this is not the appropriate time to debate that, but I can see that a contract of sale between A and A is legally difficult. But if you have an auction and an outside purchaser bids 1.2 million and Mr. Bahia is prepared to bid 1.25, all he does is he retains it at a valuation of 1.25, as it seems to me.
Yes.
And he then has to bring 1.25 into account in the final account,
Yes.
as opposed to the 1.2 at which it's currently been allocated to him.
Yes.
On the other hand, if an outside purchaser doesn't bid any more than 800,000, he can say, well, I'll have it for 810, and I only have to bring 810 into account.
Yes.
One doesn't need a conveyance to give effect to that.
Not necessarily, no, because at the moment, if he lands up being, by one route or another, the ultimate buyer, then one doesn't need, I suppose, if one can devise a route for it not to go back to the partnership, but for him to be able to buy it in any event, or to obtain it in that case.
Just
okay.
keep it.
Well, my lord, well, we wouldn't necessarily object to that. Our point is we want this to go in some way.
You want to have it tested with other bidders.
Yeah.
And you're prepared to take the risk that other bidders might not turn up.
Yes, that's right,
And
absolutely.
he might get it for almost nothing.
Or that we might bid.
Or you might get it. What about the point that it's unfair on him? Because now that all the proceeds of the partnership have been distributed and everybody's equal, which is what Mr. Temming said, he doesn't have any credit, as it were, to bid with, and he's not as cash flush as you are.
I'm not sure that's right, actually, because, my lord, I'll take instructions. My understanding is actually we've been careful to keep the proceeds in a separate account. In other words, not to go around accepting the proceeds from the Schedule B properties as a first, so to speak, as a first recipient. We've got them.
Yeah.
And so they could be distributed back, as it were.
Yes,
I mean, we have carefully not, if I can put it so, to preserve our position in the appeal, not acted inconsistently with the order we are seeking.
I see. Thank you.
So that wouldn't be a problem. That can be, as it were, the position can be restored. And the other point I would like to make on this is the following. The Harris valuation was received just yesterday. It's a draft. I've not had time to read it. And no comments have yet been invited on it from parties. One cannot take it that the Harris valuation is the final word on this matter. It is an entirely new document, which my client and I and my solicitor, I've only had a very quick chance to look at it, but not to read it. One cannot, in my submission, treat that, so to speak, as a final binding valuation, which answers our application and makes it all academic. We don't know. We might want to say the valuation should be higher, for all I know, or lower. They might want to say lower. We don't know. There's nothing to stop, as it were, Mr. Temming's client saying, hey, this is absurd, it's far too high. Whatever.
Well, with respect, there is. The judge's order said that only manifest errors can be.
I thought there was a
We're at the
process
stage
of
of
questioning built into the
There's
order.
questioning in the order. Yes, absolutely. Yes. I think I'm right, my lord. That's the point I was going to make. The actual order, I think it's in tab 5 or 6. The actual order does build in a process for questions. I think it's page 56.
Yeah. So we've got to paragraph C, which is written report in draft.
Yeah.
And then each side has 14 days from receipt of the draft to raise any written questions, and then the valuer is to answer those written questions within 28 days.
And may revise valuations if he considers it appropriate, and then you get to the final valuation.
Yes.
Yeah, and it's only the final report that is final except for manifest error.
Yes. So, in my submission, one cannot, so to speak, treat this draft report, which is right at the beginning of the process, as if somehow it is what will come out at the end of the process.
What you can say, what Mr. Temming can legitimately point to, is that as a first draft, it, on most of the properties, comes out pretty close to what the previous valuation said.
Yes, one can say that. Pretty close, yes. but without special purpose. My point about special purpose. Someone who really wants, I mean, it's clear Mr. Bahia really wants it. It's been naive to suppose that he's not prepared. On the face of it, there's real point, real prospect. He's prepared to pay another purchase, which he's obviously prepared even to turn everything on its head. He's prepared even to take the risk that he has taken about buying at the high of 2 valuation. He's happy with that. So there are grounds for supposing that actually he attaches a lot of value to these properties.
The idea of disposing of these properties by private treaty was something I think that was very much a fallback that, I don't mean to be pejorative, but sort of emerged in the course of your submissions this morning. Do you have any points to make on the point that's been made against you that the receiver, who has a great deal of experience in this area, is being deprived, if you like, of the autonomy to determine the best way of getting the best value for these properties if it just simply went into auction?
Well, our position should go. Our position is it should go into auction. That is the usual way of doing it. And if the court ordered that, then there would be no problem for the receiver. Obviously, it's a matter for the court. But in my submission, our principal position should be auction. But if it is to be by sale, by private treaty, then so be it.
What about the sort of halfway house that the receiver can decide which would be the best, most likely way to maximise the value in the properties?
Well, my lady, I think I might be hard pushed to push against that. All I can say is the receiver does charge quite a handsome fee, but if he'd be in charge of the auction in any event, that may not be such a big point.
Right.
But on either view, you would want both parties to be at liberty to bid, because your point is that if Mr. Bahia really wants the properties, he might bid more than other people, and you might want to bid.
Yes, exactly. And I think our preference would be to go to auction simply because there is then, so to speak, a gathering of buyers, gathering of bidders. I mean, as I understand it, I'm not an expert in this, you have online auctions.
Yeah.
Oh, very much so.
And our preference would be, frankly, for an auction, online auction, where everyone would be entitled to bid. But that's our preferred position, and we say that would be a perfectly efficient position, bearing in mind we know that Mr. Bahia is an interested purchaser in any event. There's not going to be the case of Mr. Bahia turning up and no one else being there.
How do you know?
Well, one assumes, and if he is the only person there, that's good luck to him.
You pick them up very cheaply.
Yes. The other point on the academic or its pointlessness and so forth is there are cost consequences. We were ordered to pay 90% of the costs below. If we're right about this being a wrong order and it's one that shouldn't be made, then we should have our costs. But below, it does matter. It's not entirely academic in that respect. And that, in my experience, won't be the same as yours, but that is sometimes a ground for letting an application for permission to go ahead.
I think you'll find there's a bit of authority on it, and that usually merely if the appeal has become entirely academic, it's normally not allowed to be pursued just for costs.
Yes.
But you say it's not an entirely academic appeal.
Not entirely academic or pointless at all, nor damaging. Well, what I do resist the notion is necessarily damaging appeal at all. It's just transferring one machinery for another. That's it.
Well,
there will be some.
You do run the risk of
We do. Yes.
going to auction and getting less.
That's our risk.
Well, it's actually not. It's
Well,
a
it's both
shared
parties.
risk.
It's both
Exactly.
parties.
Shared
Both parties.
Yes. Yes. But if Mr. Bahia is not prepared to pay, as it were, then in my submission, it's difficult to see why he should, on this footing, be entitled just to have a forced order. Well, there are risks, but we say the fairest, it comes down to the fairest way of getting the price. That's what this machinery is for.
You say the proper principle is that you've got to look to the fairest way of receiving of obtaining the value, rather than simply a fair way amongst many.
Yes. And one which eliminates the risk of one partner actually getting more than his due ultimately.
Yeah.
He gets 52%, I get 48% when we're 50-50. That is the point. my lords, my lady, it's been suggested my client is acting vindictively and so on and so forth. None of that was in evidence or before the court below. It's not part of the respondent's notice. It's nothing to do with this appeal. I learned friend also, I understand why, he keeps on saying my client stole the money, as if he sort of walked into a bank account and took it out. That's not right. Actually, the word used is misappropriated. And
Was it an honest misappropriation?
No, my lord, I don't think my lord, you see what we said, argument. But my lord,
I think
rhetoric.
Mrs. Justice Joanna Smith thought that you had dishonestly misappropriated partnership rents, and that doesn't seem very different to me.
No, well, anyway, maybe less, but even so. Briefly, my learned friend's other points. We talked about the executor point. Doesn't make a difference that we're acting executors. In my submission, you saw the authorities I took it this morning. I know Lindley says it might, but in my submission it just doesn't, and it's impossible to see on this question, the question of machinery to get the best price or fairest price, how it can make any difference. That we're mere.
I read Lindley. I should have put this to Mr. Temming, but I read Lindley saying that on a winding up, it's usually the partners who do the winding up, albeit if necessary under the supervision of the court. So they sell the assets and pay off the debts and so on and so forth.
The live
ones. And an executor or an assignee or a trustee in bankruptcy of a partnership share doesn't have that same right to actually do the winding up.
Participate as an active participant.
Well, it doesn't stop them from asking the court for things.
Yes.
That's how I read it.
Yeah. Well, in my submission, that must be right. Because it makes sense, but they don't know anything specific about how to run the partnership, and so but they can certainly ask the court what machinery should be put in place. I think the final point was the point about swift repayment. I simply endorse what has already been said about that. The running of interest is the cure for that problem. You do not, as it were, add another cure and say you will have a property transferred to you against your co-partner's will. I'm just checking my notes. I don't think, as far as the respondent's notice is concerned, we simply repeat what we say in, I think, one of our arguments in response. I can't remember the reference now.
It's dealt within your responsive skeleton.
Yeah, it's in our response. I think it's probably supplementary bundle, page 160. It's all there. Unless there's anything else, my lord, my lady, raise it.
Very good. Thank you both. And thanks for those assisting you and behind you. We will consider our judgments. They will be handed down in the usual way these days, which is to say remotely with no attendance required. And in the usual way, you will get a draft in advance of hand down, purely for the purposes of correcting our typography and obvious errors like referring to Mr. Bahia when we mean Mr. Sidhu or vice versa, not to re-argue the case. And as I'm sure you're all well aware, at that stage it will be subject to an embargo which must be strictly observed. Once you've corrected the typographical errors, please attempt to agree a consequential order. We appreciate from the debate that we've had today that may not be straightforward. And it may be that you will want more time than we normally allow for that process. So it might be worth thinking about that ahead of time before you get the judgment. I appreciate it's difficult when you don't know what the outcome is going to be. But just to explain, typically you will get a judgment, I mean, it varies depending on circumstances, but it's often 3 or 4 working days ahead of hand down. And in the circumstances of this case, I can see you may need a bit more time. And there's no rule that prevents you from asking for more time after hand down to try and agree an order. But think about what the practicalities are and how best you're going to be addressing those as and when. All right?
he's concerned.